Hi friends, welcome or welcome back to my channel. My name is Bethany, and on this channel we talk about the false beliefs taught to women inside of the church. So if that is something that resonates with you, go ahead and subscribe to this channel, share it with a friend, and always hit the notification bell so you will be notified every single time that I drop a new video. Also, come follow me on Instagram and sign up for the Outspoken Exfundie Newsletter so you can receive videos 12 to 24 hours early before they go public. Now, I'm excited for today's video because we are reacting to Brittany Dawn's court hearing. And I honestly didn't know that this was going on. I didn't know that there were any hearings going to be coming about soon. I actually saw it on Camelia's channel. I'll put that specific video in the description box below because she actually helped me find this court video so I could also commentate to it. But I noticed other creators doing reaction videos to this court hearing, and I was like, oh my god, I don't want to watch anybody's. I just watched Camilla's, but I didn't want to watch anybody else's because I didn't want my opinion to be kind of swayed. So I've already seen it. I've already watched it because I watched a video of it already, but y'all will just not believe. Y'all will just not believe what's going on. So if you do not know who Brittany Dawn is and you don't understand what this court hearing is about, I would definitely suggest you to go watch my previous video on Brittany Dawn. That really gives the backstory as to why she is being sued by the state of Texas. I don't really want to get into the details here because we've already been there. We've already done that. So if you don't know, that's totally fine. Just go watch that video and it'll give you a lot more insight into what's going on. Now, before we get started, if you find that I look a little put out during this video, it's not only because we're watching a Brittany Dawn video, but it is because I do not feel that great at all, and I'm extremely tired. I've worked all day today, and it's almost, oh no, it is 10 o'clock. It's 10 o'clock at night, but I really wanted / needed to get this video out as soon as possible because this weekend my husband and I will be gone to BFE, Missouri, where we will not have any sort of Wi-Fi, self-service, nothing. So I really wanted to get this out for y'all because it's such a new up and coming thing that's going on. Okay, let's get into it. Before we dive into the court hearing, I did want to give y'all a little background as to why they are doing this court hearing. Because when I watched it, they do use a lot of legal jargon, and I just wanted to put it in layman's terms so you'll kind of understand. We are going to watch all of it. It's about 23 minutes long, but I wanted to give you a little, like, why they're doing it. Okay, so why they are having a court hearing right now is because the state of Texas, essentially, this is how my brain is comprehending everything. Essentially, the state of Texas has been consistently asking Brittany Dawn and her lawyer to come up with the names of the clients that she had, the packages that they purchased, the date as to which they purchased it, and the prices of the packages they purchased for these fitness programs, for nutrition programs, things of that nature, because Brittany Dawn Fitness LLC was an online business. Therefore, there should be documents online that have the client names, packages, you know what I mean? So the reason why they are having this court hearing is because the state of Texas has been asking Brittany Dawn and her lawyer for that information, which should be completely easy to get if you have an online business. However, month after month after month, they have not produced this for the state, to the state of Texas, rather. They have not given this information to the state of Texas after being asked several times, which you'll hear in the court hearing. So that's why they're having this discussion with the judge saying, hey, essentially to proceed with this lawsuit, we need this information, but they haven't given it to us. Like, you're going to have to make a deadline for them so they know that the state of Texas is serious. That is essentially what is going on. Okay, let's do it.
All right, good afternoon.
Good afternoon, Your Honor.
Good afternoon. We are on the record in cause number DC 22-01388. It is styled State of Texas versus Brittany Dawn Fitness LLC et al. May I have the parties to briefly announce on the record for me? Let me know your name and who you represent in this action.
Yes, Your Honor. My name is James Holian. I'm an Assistant Attorney General, and I represent plaintiff, the state of Texas.
All right. Mr. McLean, you're on mute.
I'm sorry about that. My name is Calvin McLean, Johnston and McLean in Plano, and we represent the defendants.
Okay. All right. And Mrs. Dawn, are you appearing in this particular hearing or just here observing? You're on mute right now.
That is our client, Your Honor.
Okay.
She will simply be here to observe.
All right. Are there any other announcements?
Your Honor, I can just identify the other persons who are present. The person who is listed iPhone parentheses 137 is my co-counsel, Jamison Joyce, who is also with the Office of the Attorney General. And listening in today with the name MEW5 is actually a University of Texas intern, undergraduate intern with our office, who's going to be watching today's hearing, Mallory Weigel. And then Kristen Vasquez is the managing attorney of the Austin Regional Office of the Consumer Protection Division.
All right, no problem. What is set today is the plaintiff's motion to compel. Is that correct?
Yes, Your Honor.
All right. I know there's been a response that has been filed to your motion to compel. So I'll hear from the movant first, and then I'll give the defendants an opportunity to respond.
Thank you, Your Honor. What I'm going to do is just from the top is state my goal, Your Honor. The state is going to request that you grant the state's motion to compel defendants' responses to the first set of interrogatories and request for production of documents. And in so doing, would ask that you provide a firm deadline to provide complete and verified responses. And in our motion, we set 10 days on something that's already been 158 days in the making, as a firm and final deadline on a case that has a jury trial set in 5 months from today. So with a little bit of factual background, I'll try to make this brief, Your Honor, but I want to give you just some brief factual background. The state filed this case in February of this year for violations of the DTPA, the Deceptive Trade Practices Act, using the consumer protection portions of that act that are specific and exclusive to the Office of the Attorney General, and are doing so on the grounds that defendants have engaged in false, misleading, and deceptive acts and practices in the conduct of trade and commerce. Now, what is that trade and commerce, Your Honor? In this case, we are alleging that the defendants have made over $1 million in the sale of online packages to thousands of consumers throughout the country.
Over $1 million. She did not earn. She received over $1 million from these thousands of women that I don't want to say she scammed all of them, but allegedly she scammed thousands. Not saying that every single woman that paid for a service didn't receive, but there were obviously thousands. They came out and said it, but over $1 million.
With the promise of personalized nutritional guidance and fitness coaching. The plans themselves on the websites ranged from $92 for a one-time consultation or a 1-month training and fitness plan, to $300 or more for multiple months of training.
$92 for one consultation? What? What? So, like I said, I've seen this before because of the previous video that I did watch when I didn't know this hearing was like a thing. And I know that I'm going to pick some things up that I didn't either hear and or pay attention to, and that's obviously one of them. $92 for a consultation? Do you know, as a certified personal trainer and somebody who has a degree in health promotion and wellness, do you know what I ask for a consultation? That much. 92? What are you doing in this consultation? That's weird.
Fitness. However, the state alleges that these nutrition and fitness plans were not individualized. The defendants failed to provide the promised coaching and modifications, and that so something that started at the tail end of 2013, 2014, we're not 100% sure on that start date yet, abruptly ended in early 2019 after national media ran stories about these consumer complaints. A group of consumers had banded together and started making noise about what they felt was an injustice to what they were paying for and not receiving. That received national media attention, prompting an apology video on YouTube, and the websites came down in 2019. So, Your Honor, that takes us to our discovery dispute. We did an exchange of initial disclosures per the new rules. And on April 7th, 2022, the state served its first request for discovery. And admittedly, Your Honor, it's comprehensive, but our goal was to get at the meat and potatoes of this case quickly so that we could jump into depositions and be ready for trial. Now, defendant's attorney requested and plaintiff granted 4 extensions for a total of an additional 48 days to respond to this discovery. Again, acknowledging that it was a comprehensive amount of material we were requesting, wanted to work with them. So defendants had until Friday, June 24th to respond. They did not timely respond. They, on Monday, June 27th, served incomplete and inadequate responses. That's Exhibit A to the state's motion, which we won't go through line by line. I'm not going to waste the court's time. We did some meet and confer and basically gave them an additional month till July 25th, 2022 to address the discovery issues. Defendants agreed, and defendants agreed to provide complete and objection-free responses. Defendants did not respond by that July 25th, additional month. Instead, the day after the 25th, I had to send an email going essentially, where are the responses? The following, within 8 minutes of my email, we got where I said I would unfortunately be needing to file a motion to compel and involve the court in this dispute. We got an immediate response that they would be serving responses shortly, et cetera, et cetera. July 27th, so 2 days later, they served defendants' first amended responses. Those are also attached and they are Exhibit G. And you'll see in those responses, they have removed all of their objections. Unfortunately, even with the objections removed, it's still evasive and incomplete. For example, things like, we will supplement later. Your Honor, supplementing later from a plaintiff's perspective doesn't work. We need to know the universe of the material, the facts that will be available to the state to prove or disprove the claims at this time. My understanding, and I would argue the purpose of supplemental discovery is later acquired information. You go down the road and you later find, you hire an expert and they provide an opinion. Now you might need to supplement your discovery in a particular way, but not as an excuse to not provide timely, complete, and full responses at the time discovery is due. Now, Your Honor, that brings us to the present. Just yesterday evening, September 8th, 2022, defendants provide additional answers. So a second supplemental response to the interrogatories and the request for production, and nearly 10,000 pages of additional documents were provided yesterday. Now, at 11:15 at night, Your Honor, they also e-filed a defendant's response to the motion to compel. And Your Honor, plaintiff takes some issue with the way that things are characterized as far as the timeline and extensions.
Number one, I'm not a lawyer, obviously, and I've never been in a situation like this, but sending 10,000 documents to save your ass at almost midnight before this court hearing, this is all in my opinion, obviously, but it makes them look unprofessional. It makes them look unorganized. It makes them look like they're trying to not so much cover something up, but like continue to hide something, because they extended it, 5 times. They extended it 5 times, and then they finally gave him some answers to what he was requesting almost at midnight the night before the hearing. Like, man, something isn't right.
The factual summary in there is inaccurate and incomplete. Defendants seem to imply that they had made efforts to seek a 5th extension, and that somehow that 4th deadline was maybe the plaintiff's fault, that the responses were deemed late. But I don't see any argument at that stage as warranted, Your Honor. They've already removed their objections from the first amended responses in Exhibit G. They waived their objections. The simple fact of the matter is plaintiff didn't agree to yet another and more continuances. Plaintiff had been waiting long enough to get these documents. And then in Exhibit G, it's interesting in there, some of the arguments that they make in this response to the motion to compel, Your Honor, is basically saying that in order for them to fully respond to interrogatory number 5D and number 7, that they would have to review more than 50,000 pages of documents and look for information about individual consumers. And it's interesting because this is the first time they're saying that, in that Exhibit G, they said they would supplement after they review their documents, and they would provide a customer list with names and dates. And now here they are at the 11th hour before a hearing on a motion to compel, basically making it sound like, well, the plaintiff can do this work for themselves. We'll just provide them all the documentation, and they can come up with their own list. Well, that's not what they said in response to Exhibit G. And I would argue that Texas Rules of Civil Procedure 193.2 and .3 make it very, very clear that a party is required to produce all information requested unless the party serves a timely objection or assertion of privilege, neither of which happened in this case. A couple quick final notes, Your Honor, that I'll make more to just the concept of what the state's entitled to and why. The Texas Supreme Court says that the purpose of discovery is to seek the truth so that disputes can be decided on what facts are revealed, not what facts are concealed. And in a case like this, Your Honor, defendants hold the cards. We're in their responses to interrogatories and in their request for disclosure, they are denying the allegations of the state. They're denying these violations. And one such example is basically saying, Your Honor, that all these consumers received the coaching that they were promised. And that is a statement that was made, verified in these interrogatories, that they received all the coaching. Well, Your Honor, that's against the greater weight of hundreds of consumers who have come forward to the state and said, we didn't receive the coaching we had requested. So to that end, Your Honor, I need to see it all. I need to see all the material to understand who did and didn't receive coaching so that we can determine as as is a core DTPA, instructions, the nature, extent, gravity of the alleged violations. Under the DTPA, in order for me to be able to prove to your honor and to a jury the nature, extent, and gravity of the violations, it is essential, it is necessary that the state receive these documents and these evidence. And what I don't want to have happen, your honor, is for us to get to trial and have received what we believe is complete documents and prepare a case to present to a jury to say, this is what has happened. These were the consumers who did or didn't receive their promised coaching. And then to have defendants testify or try to produce evidence at that 11th hour going, well, no, we actually do have emails of that, or we did have coaching of that. I just didn't produce at the time. I didn't find it at the time. Your honor, that's exactly the type of thing we're trying to proactively prevent by asking this court to say, the defendants need to produce everything, or they need to be at risk of issue sanctions for not complying, or discovery sanctions with not complying with this court's order. Defendants seem to have a hard time following the rules so far, your honor. Your own court's order is that responsive pleadings be sent to the court 48 hours before for your briefing. That was not done. The rules with respect to when.
Man, I gotta give it to this James Julian, whatever. He's a very well-spoken lawyer, and everything he said, he is just very nicely throwing them under the bus, and it's pretty cool.
Discovery was due. It's been really difficult to get complete and non-evasive material. We've been waiting 5 months for it now, your honor. We've only got 5 months before trial. We want this to end today.
All right, Mr. McLean.
Yes, Your Honor. I just want to start with our goal, and our goal is simply to move this case forward. We've been open, transparent, and communicative with the AG for the entirety of this process, Your Honor. This case involves Ms. Nelson, is no longer Davis. And thus far, we've produced 52,747 pages of documents. That is the entirety of the documents that Ms. Nelson has responsive to the AG's request. She doesn't have anything else in her possession at this time. They have it all. I believe the main thing that the AG wants at this point, and we don't mind giving it to him, Your Honor, it's just that it's gonna take additional time, is number 5D, which states, identify the total number of consumers who purchased each plan. So there are a number of plans. There is no master list or any list at all of customers.
No. This part is where a lot of my opinions come out. I mean, I have a lot, but this part doesn't make sense. This is what I was telling you at the very, very beginning. The reason why they're having this court hearing is because the state of Texas is telling Brittany, hey, we need a list of all of the clients who paid for packages under Brittany Dawn Fitness LLC. Sure, because everything was online. Now, he just said that there is no master list, there is no master whatever, saying they can't essentially have one master list saying a customer or client rather bought this package at this price at this time, whatever. No, there has to be, because these people purchased the packages online, and she had a website and she used PayPal. And I also use PayPal for my clients. I also use PayPal for my social media virtual assistant clients. And you can see, this is where things get a little, you can see the person who purchased what item, at what time, at what cost, and you can just see all of it. So you have that information in PayPal, not just PayPal, but you should have the information on the website as well. But the thing is, in 2019, they just said it. She put this, completely deleted, deactivated her website, and I'll also give more opinions after this.
So it literally will require, and it has required, our client to go through each page of these documents and physically type in the name, because in number 7, identify is referring back to 5D, identify the name, address, and telephone number of each consumer, and identify the month and year the consumer purchased the plan.
Why does she have to manually do that when this was all online? And then my next question is, if she is manually writing these down, is she writing them off of the computer and writing it down? If so, why don't you just make that like a PDF or an Excel sheet like she probably should have at the beginning if you're a good organized business owner who has made over $1 million doing this, and then print that out and there's your information. I don't understand where the miscommunication or the misunderstanding is for this such simple assignment that the state of Texas is asking her to do.
We don't mind doing it. In our response, we simply say they may be better suited to do it, but in our order, if you read our order, we ask that you either deny their motion or that you give us a reasonable amount of time to complete this task. Thus far, our clients have
they've already had 4 extensions. How much more time do you need?
Produce 1,500 names in a chart that satisfies 5D and 7A and B. We believe that we probably have about 3,500 more to go, and it's just a tedious task. We referenced.
Let me just ask a question regarding, I guess, how this information is kept. If this is an online sales, online transactions, I guess why would you have to go through them physically if it's being captured online at some point in time?
Exactly. Honorable Monica McCoy. Exactly. I'm a fan of this judge for sure.
Just a question on my end, trying to understand how the information is maintained.
Yes, Your Honor. So for first things first, all transactions were conducted through PayPal, all payment transactions. Our client has been locked out of her PayPal account. We've communicated that to the Attorney General's office. We've even mentioned that maybe they should subpoena the PayPal account because our client does not have access to it.
Here's another opinion. And this is my opinion only. And this is also a theory of mine. Okay? So, this is my theory. They said that everything was done through PayPal. Literally what I just said earlier. And I see my clients every purchase on there. Every single month. I see it. Okay? You can print that shit. You can export it into Excel, into whatever PDF, whatever you want. You can print that out. Okay. Anyway, so here's my theory. Here is my opinion. He just said that it was all done through PayPal and she is locked out of PayPal. Okay. PayPal as the corporation ended up shutting her. Okay. I don't want to say they shut her PayPal down, but she can no longer use PayPal at all. So here's my theory. I think when she got found out in 2019 and she completely deactivated her website, I also think she deactivated her PayPal account because she knew that she could see all of the client's information on there. And you can type messages in there as well, which I just remembered. You can type messages in there as well. So it makes me wonder if she actually deactivated it, because PayPal might be one of those accounts where if you deactivate it, all that information is no longer available to you. So they're saying, well, she's logged out of her PayPal account and they won't let her back in it. I feel as though if that was the actual issue, that this could be solved so easily, because this is a lawsuit within a state, within the state of Texas. Meaning, if they needed that PayPal information and it was just a login they needed, the lawyer could call PayPal up, because I've called PayPal several times over the years. Call PayPal, hey, I need access to my client's PayPal, but she no longer can log in, blah, blah, blah. Can I go down to the office? Because they still have a building. Or can I speak to whatever? What do I need to do in order to access her PayPal? She may not need it. Like, she may not access it, but I need to access it. Like, if the state of Texas is needing that, like, I would feel as though they would have to do it, but they're not making those necessary steps to try to log back into her account, because I really think it's not a login issue. I truly think that she deactivated it with all of her other website information. So it was like, out of sight, out of mind. It never happened, and nobody can see what I did. Nobody can have proof of me taking money, or I don't have to be held accountable for the things that I did if there's not a money trail, or a number trail, or a name trail, or a paper trail, whatever. But now they're asking for it, and in my opinion, again, a theory, that attorney and Brittany is just like, well, like, we have to come up with something here. Let's start writing, things down, or like go through your Facebook Messenger and write these, or whatever. I don't know, but I really think that she ended up deactivating her PayPal account, because this doesn't make any sense. But because PayPal for sure, like, won't let her use PayPal anymore, but I think she deactivated it. I really do, because they go on to say, like, whatever, we'll just listen.
And it's in their exhibit E, where we mentioned that. We told them the difficulties we were having in getting in PayPal. In exhibit F, their exhibit E. In their exhibit F, we discussed the difficulties our client was having downloading the documents into PDFs. We're getting a lot of PNG files and JPEGs. We have no problem, Your Honor, disclosing this information. They have the same documents we do.
Do you know how simple it is? There are apps for this now, that if you can even change an MP4 to an MP3 by a click of a button. You understand how silly this sounds? If you can download something as a PNG, I think that's what he said, PNG, whatever the hell. If you can download it as that, all you have to do is either download on your computer, or like in your phone or whatever, a converter, a file converter, and it will convert it to a PDF. Like, I don't know if he understands how silly this sounds, or he truly is like, well, I don't know, we just can't find a way to do it. No, if there's a will, there's a damn way.
If you order us to go through them, we'll do it. It's just going to take some time. And it's not a physical paper file, 1, 2, 3, but it is looking through the digital pages one by one in order to capture the names of each customer and the requested information.
All right. Council response?
Yes, Your Honor. 2 points. One, if they don't have any more documents, and recall, Your Honor, nearly 20% of that 50,000 documents were produced last night. I wouldn't be able to tell the court today whether the state considers that now a complete response. So the state would still ask for an order compelling complete responses within 10 days and if they have produced everything, then there will be no problem complying with this order. If all those documents have been produced, then essentially that part of the order has been taken care of, and it will set in the state's view, a very firm position that this is not an ongoing supplemental, provide a couple additional dots when you feel like it, as we edge closer and closer to a trial date, or as the state tries to prepare for depositions. My second point, Your Honor, is, defendants mentioned that this is a tedious task. Discovery, unfortunately, as we know, lawsuits are expensive. The discovery is tedious. There was discussions with Mr. McLean when we were meeting and conferring that he had proposed to his client hiring a third-party company that does these document data pulls from various files in your computer and takes care of it. And it doesn't look like that's a direction that they went. And I'm not here to tell them how to spend their money or how to prepare their case, but to act like a civil investigation and a civil lawsuit from the state of Texas for violations of the DTPA isn't potentially a tedious and expensive thing, Your Honor. I wish I could say it wasn't, but the reality is these are borderline complex litigations, and it's going to be tedious. What we don't want, Your Honor, is this to be a prolonged, overly delayed process, and that's why we're here today.
All right, let me say this with respect to the motion to compel. And let me just understand, I guess, Mr. McLean's argument that obviously objections have been removed. There's no problem responding to 5D. The problem with responding to 5D is the timing in which to respond to that. Now let's talk a little bit about what the rules require. Typically, in a motion to compel hearing, this court, if it is going to be difficult to retrieve it, this court obviously needs some evidence of that. Obviously, you've offered me some argument, Mr. McLean, as to what it's going to take from your client in which to respond to this discovery request. And so this court has to balance that. And what this court is basically looking at, discovery, of course, was propounded back in April, and we're in September still trying to get this particular information. So I understood you to say it's going to take some time, Mr. McLean, but I need to know how much time, because if I put it in this order, you're going to be bound by this order. And I don't want to obviously allow 30 days when discovery was propounded back in April.
I have discussed this exact issue with my clients, and they would request, and I know you said you wouldn't want to give 30, but they said realistically it would probably take them 45 days to complete it.
It'll take 45 days when they started this in April. They're asking for an extension of 45 days when they asked for it in April. That is mind-boggling. And I love what the judge said, because she said, yeah, I understand that there might be difficulties, but now we need evidence, like we need proof of these difficulties, meaning we need proof now that you cannot get into your PayPal account, meaning she has to prove if she deactivated it or if she really just got logged out and she can't get back in. Like, there has to be some type of evidence to that, which is very interesting.
This list, and since the last, and Mr. Holy and I have had many conversations through email and on the phone. So I haven't been hiding the difficulties that we face in getting documents in this case. I have not withheld that from him. I've been open with him about that, and it's present in 2 of his exhibits. However, as far as hiring a third-party company, that's just something our clients could not do, and it's just going to require a little more time to go through them one by one. We've been open about that. We even had a conversation about that exact thing, Mr. Holian and I.
All right. Any response from the movement, Mr. Holian?
Your Honor, just reiterating, it sounds like this court is inclined to grant, and I would ask that something, I still stand by the 10 days, but if the court's inclined to give them more than that, but less than 30, we're going to work with the court's order. We're grateful for the opportunity to have a very firm deadline and to move this case forward.
All right. I'm going to grant the plaintiff's motion to compel. I'm going to order the defendant to respond to the discovery that has previously been propounded upon them no later than September 30th, 2022. So they're going to have to figure out how to get it done by that time. That you all need to be getting ready for trial. You still have to mediate. There's still a lot of things to do. I've signed an order to that effect, and this order will be uploaded on Odyssey by the close of business today. Is there anything further before we conclude the hearing?
No, thank you, Your Honor.
Mr. McLean?
Nothing further. Thank you, Your Honor.
All right, that concludes our hearing. Thank you so much. Take care.
Yes.
September 30th. Oh my God, I love it. So that, I believe that would have been around 2-ish weeks. So instead of the 10 days, she was giving about 2 weeks, but not 30, not 45, about 2 weeks. And of course, please put your commentary down below. I would love to know what your opinions are, what your thoughts are, what your theories are of what is going on, because this is very, very interesting. And I definitely look forward to seeing the next court hearing, whenever that might be. But man, in my opinion, this is making them look super bad. And not just super bad, but a little shady and pretty guilty. Again, let me know what your thoughts are. Now that that video is done, this video is going to be done, and I am about to go to sleep. So always remember that you are a fierce and powerful motherfucking woman, and I appreciate you so, so much, and I will see you in the next one. Bye.